Assalamualaikum and hi. Today I want to share about intention to create legal relationship. Before that, I want to introduce myself. Hi, my name is Ritas Amani binti Kamarudi. This is a group assignment for business law subject, and the name of our lecturer is Ms. Fatiha Zahira. Before I start, I want to introduce my group members. That is Nurul Kamisa binti Johari, Nur Syahada binti Hasni, and also Siti Sarah binti Azini. For your information, we take the same course, that is Diploma in Business Management. By the way, the title that we have chosen is In the Law of Contract. We will explain this title with related case, so stay tuned.
Introduction. The requirement of intention to create legal relation constitute one of the most significant conditions of a valid contract in many jurisdictions around the globe, both developed and developing. Contract Act, being an act governing relation between private parties, cannot be interpreted in the court of law without giving much weightage to the intention of the parties forming such contract. To prove the existence of intention to create legal relation, in addition to prove the existence of consideration becomes quite burdensome at times. The main argument of this paper is that consideration in itself and should ideally be indicative of such intention. Therefore, as far as common law, contrary are concerned, consideration in itself should be capable of dealing with the intention of the parties, and there should not be any separate requirement of proving an intention to create legal relation. It is pertinent to note that there is a divide between the common law countries, where the Western country, example US and UK, require the establishment of intention to create legal relation, in addition to the existence of the consideration, but emerging economies like India and China does not require it. Moreover, to decide whether such an intention is present in a particular agreement between the parties, the court starts with initial presumption depending upon whether the agreement is originating in a domestic setup or is it purely a commercial transaction. Commercial transaction becomes difficult in some situations due to increasing interaction between the family relation and commercial relation, thereby blurring the distinction between domestic contract and commercial contract. The real intention might never come to the knowledge of interpreter, and in such situation the dilemma of how to gather the existent or non-existent of such intention haunt the very decision based on it. Another problem arises when parties to the contract comes from different social and cultural background and therefore perceive differently in a given situation.
Definition. What is intention to create legal relation? Intention to create legal relation means a contract is legally binding agreement. Once an offer has been accepted, they are an agreement, but not necessarily a contract. The element that convert any agreement into a true contract is intention to create legal relation. There must be evidence that the parties intend the agreement to be subject to the law of contract. Alright, next. If evidence of intent is found, the agreement gives rise to legal obligation whereby any party in breach may be used. Then, in English law, there are two judicial devices to have a court to decide whether there is intent. First, the earlier, using objective test, and the later, using rebuttable presumption.
Objective tests. Objective tests are measures in which responses maximize objectivity, in the sense that response options are structured such that examiners have only a limited set of options. The best way of discovering whether the parties intended to contract is not to ask them, as this subjective test would give the rough and easy loophole to escape liability. He would reply, "No, I did not intend to be bound." Instead, just as in Khalil against Carbolic Smoke Bowl Company, the court applied the objective test and ask whether the reasonable bystander, after taking into account all the circumstances of the case, think that the parties intended to be bound, since the advertisement picture state that the company had deposited £1,000 in the alien's bank. To show sincerity in the matter, the court held that any objective bystander who read this would presume an intention to contract.
The rebutable presumption. Both in common law and civil law, a rebutable presumption is an assumption made by a court that is taken to be true unless someone comes forward to confess it and prove otherwise. For example, a defendant is in criminal case is presumed innocent until proved guilty. A rebutable presumption is often associated with prima facie evidence. What is a prima facie? Prima facie from Latin is a Latin expression meaning on in first encounter or at first sight.
There are four classes of agreement: family agreement, social agreement, commercial agreement, and collective agreement. Family agreement. Family agreement are presumed not to give rise to legal relation unless there is clear evidence to the contrary. The courts will dismiss agreement which, for policy reasons, should not be legally enforceable.
Case example: Balfour against Balfour in year 1990. The husband brought wife to England from Sri Lanka. The husband had to return but wife stayed for medical reason. He promised to pay her £30 per month until his return. When he failed to pay, the wife sued the husband. Wife action failed because there is no consideration moved from her and there is no intention to create legally binding agreement found. The court stated in husband and wife cases, burden of proof is on plaintiff to prove intention to create legally binding agreement.
Social agreements. With social agreement, there is no presumption and the case being decided solely on its merits. Case example: Simpkins against Page in just 1955. The case shows mutuality. In this case, the defendant, her granddaughter, and the plaintiff paying lodger regularly to fight in newspaper competition. All contribute but enter in defendant's name. There is no set of arrangement that state payment of postage, etc. When entry of the competition is successful, defendant refused to share with plaintiff. The plaintiff sued for his share. Court ruled legally binding relationship as sufficient mutuality in the arrangement between parties.
Commercial agreement. A commercial agreement is a legally binding contract between parties where both are required to do particular activities or refrain from doing something. They can be found in a variety of business types, including industrial, corporate, and retail. For the case example, Cleanworth Benson Limited against Malaysia Mining Corporation Berhad in year 1989. In this case, the plaintiff bank agreed to loan to MMC Metals, subsidiary of MMC. The bank asked MMC to guarantee loan. MMC said not policy to guarantee loan to subside offer letter of comfort stating, "It is our policy to ensure that the business of MMC Metal is at all times in a position to meet its liabilities under arrangement." The bank accepted but charged higher rate of interest and the market collapsed and MMC went into liquidation. The plaintiff tried to claim balance from MMC. First instance, the court found in favor of plaintiff, relying heavily on Skyway 1964, ruling overturned on appeal, and the judge said Skyway case note was about promise supported by consideration, so not applicable here. Hence, rule not intention to create legally binding agreement statement was not meant to act as guarantee, stating on current position, not future intention.
The last topic that I will explain is collective agreement. What is collective agreement? Okay, a collective agreement is written contract between the employer and a union that outline many of the terms and conditions of employment for employee in the bargaining unit. The kind of term and condition covered by collective agreement typically include wages and benefit, as well as term and condition of employment that related to. Alright, for example, job posting, obligation and responsibility of the employer and union, and also a dispute resolution process is usually a grievance and arbitration procedure. What is collective bargaining? Collective bargaining is a process in which a union and employer negotiate a group agreement. In this process, the parties usually focus on such issues as wages, benefit, and also working conditions. Case example, Ford Motor Company, the Amalgamated Union of Engineering and Foundry Worker 1969. Ford Motor and Trade Union reached collective agreement concerning employment conditions signed by their representative. When a union strike took place concerning the condition, the company brought an action for a judgment pursuant to the agreement, and also attesting the collective agreement to be legally binding. And lastly, the union agreed that no enforceable contract resulted from the collective agreement.
Conclusion. The discussion on the subject of intention as one of the important ingredients of a valid contract is well debated by not only scholars but also courts. The paper has attempted to unfold the various aspects spinning around the discussion. The paper strongly argues for abandoning in the requirement of proving intention to create legal relation in case of countries that require the existence of consideration for forming a valid and enforceable contract. Therefore, in case of common law country where consideration is one of the institutions of a valid contract, the requirement of proving intention to create legal relation should not be pressed upon. The consideration in itself can be taken as a proof strong enough to indicate the presence of intention of forming a legally binding contract.
First off, what is law? Law can be defined as that which is laid down, ordained, or established, a rule or method according to which phenomena or actions coexist or follow each other, and which must be obeyed and followed by citizens, subject to sanctions or legal consequences. Sources of law: custom, actions of representatives of people, decisions of the courts, precedent, or actions of administrative agencies, agreements between people. The role of the courts: be arbiters of the Constitution, interpret legislation, protect our civil liberties, enforce public policy, be arbiters of disputes between private parties. The litigation process. First of all, you have the demand letter. This is a formal letter explaining the situation and asking for money or giving the alternative of going to court. Secondly, you have negotiation. This is when the defendant replies, sometimes with the possibility of a settlement. Third, writ of summons, a document that establishes the plaintiff and defendant and what location they'll register in. Fourth, statement of claim, an explanation of the issue. Both of these are served to the defendant. If either of these are ignored, the plaintiff could take default judgment and win. Fifth, you have the appearance, documents establishing that the defendant will appear. 6. Statement of defense. This is an explanation from the defendant's side. 7th, you have the reply. All these factors are part of the pleadings process that usually takes approximately 3 months. Number 8. Demand for discovery of documents. All relevant documents must be disclosed at this time. Number 9. Interrogatories. Written questions asked by both parties. Number 10. Examination for discovery. Questions that are asked in a law office and recorded to be used as evidence later in court. Number 11. Set trial date. Note that the settlements often happen right before trial. Next, we have number 12, which is the trial itself. This is when all the factors and events that normally occur during a trial take place. Following that, we have number 13, which is the appeal process. Next, we'll be looking at tort law. Tort can be defined as a wrong to another person. Next, we'll define liability. It is the requirement to pay damages. The first liability is fault. For example, when the janitor was at fault for not posting a wet floor sign that caused an injury. Second, we have strict liability. We can look at one of our examples from the textbook for this one. There's a man named Rylance who had a reservoir. Next to his reservoir lived a man named Fletcher, and on his property, he had a mine. Ryland's reservoir started leaking water into Fletcher's mine, thus ruining the mine and creating a danger, making him liable. Third, we have vicarious liability. This is when an employer is responsible for actions of their employees. Now, we'll look at the negligence formula. For someone to be found liable, the following factors need to be present. There needs to be a duty of care owed, breach of standard of care, causation, and remoteness. And if you have all those, then you have a liability. But you need to keep in mind that there may be contributory negligence involved. The first one that we'll look at is duty of care. The famous case for this is Donahue versus Stevenson. In this case, Mrs. Donahue was enjoying a nice ginger beer when she found a snail at the bottom of her beer. She thought Mr. Stevenson, the manufacturer, was liable because he owed her a duty of care. Lord Atkins' definition is that you must take responsible care to avoid acts or omissions which you can reasonably foresee would be likely to injure your neighbor. Next, we'll look at breach of standard of care. Does the conduct fall below what the standard of the position is? An example that we looked at in class is how a truck driver named Chauncey was below the normal standard because he wandered to the side of the road. Next, causation. The act of causing something that makes you liable. Now we'll look at remoteness. Whatever occurred must be reasonably foreseeable. In the Long Island Railway case, there was a man who was trying to catch up to a moving train. 2 employees successfully helped him onto the train, but while doing so, one of the man's packages carrying fireworks fell underneath the train. The train just happened to set these fireworks off. There was a woman standing down the tracks who was injured by the explosion after shockwaves knocked over a scale. Next, we have contributory negligence. This is when there's a failure of an injured plaintiff to act prudently. The most common example of this is when the injured plaintiff isn't wearing their seatbelt. Other torts. First one being deceit or fraudulent misrepresentation. This is when there's action used to deceive another. Next, we have assault and battery. Assault is the threat of the violence, whereas battery is the actual intentional harmful contact with the body of another. So we have nervous shock, when intentional or reckless conduct causes emotional distress. False imprisonment, intentionally restraining the movement of another without lawful justification. Malicious prosecution, having someone prosecuted without cause and with malicious intent. Defamation, lowering a person's reputation in the eyes of right-thinking members of society. Alternative dispute resolution, or ADR. Any process used to resolve a dispute outside of litigation. It's hard to say, but we can weigh the advantages and disadvantages to see which one we prefer. Some of the advantages are that there's usually lower cost, reduced time to resolution, preservation of confidentiality, greater control over process and outcomes, business advantages, and specialized expertise and opportunities for conciliation. Some of the disadvantages are possible inequality of bargaining power, lack of enforcement of documents and information disclosure, possible lack of finality, enforcement challenges, and less safeguards on the process. Types of ADR: negotiation, confidential listening, mediation, neutral evaluation, mini-trials, arbitration, ARB-MED, and MEDALOA, mediation, and last offer arbitration. Formation of a contract, offer and acceptance. There are 6 general rules for offer and acceptance. First one is that a contract doesn't exist until an offer is made by one person and accepted by another. Second, an invitation to do business isn't an offer. Third, an offer must be communicated. Fourth, an offer does lapse and can lapse in 3 ways. First, if a specified time period has expired, a reasonable time has expired, or either the offerer or offeree dies or becomes insane. The 5th rule is that any offer may be revoked at any time prior to acceptance. And the 6th, the contract becomes binding the moment an offer is accepted. Finally, we have a unilateral contract. When the offer indicates performance initiates the contract instead of acceptance, like the Carbolic Smoke Act.